Oh, hey, sorry. Thanks, Joel. Hey, everyone. I think as Joel may have explained, I'm not sure, I wasn't able to make it into the office in Minneapolis today. I'm actually down. David and Cal asked me to fly down to help with the grand opening of the Faegre Baker Daniels Costa Rica office. So I'll be here for probably a couple months just helping them set up shop and everything. But it's great to see everyone. Thank you for letting me participate today. So the case I have is Teva v. Sandoz. It is from February in front of the Federal Circuit, and the court granted cert on March 31st to deal with the issue of the standard of review for claim construction. So currently, under the Federal Circuit's jurisprudence in Cybor, which was a 1998 case, it's de novo. But as you're probably aware, findings of fact typically are reviewed for clear error under Rule 52. And so there's kind of some tension that's always existed since Cybor with that ruling, and we'll kind of talk about that. The opinion in Teva is not really actually that important to the issue here. It's actually going back a couple other opinions that we'll talk about. Teva dealt with basically some patented biomedical treatments, and specifically the term at issue was molecular weight as it applied to copolymers. And the question was whether or not molecular weight included one specific description of a copolymer that was either based on like the mean or the which copolymer was most abundant, or whether or not it kind of was more indefinite and allowed all three. Or allowed any kind. And the Federal Circuit overturned the district court's finding that it related to one of those specific measures of the copolymers, and found the claims to be indefinite. And so the patentee filed or petitioned for cert, and so that's where we are. But really, other than that, they don't address the issue too much. There isn't kind of the back and forth in Teva. It's basically the case Lighting Ballast Control versus Philip Electronics from 2014 is really where you see the courts sparring over this issue, and so that's really going to be, I think, the big issue in front, or the case that's kind of in front of the court. That case was a 6-4 ruling with two judges abstaining. And so the majority there upholding the standard of review as de novo was written by Judge Newman, with Lurie consenting, and then the dissent was O'Malley with Rader, Renya, and Wallach joining the dissent. And it's actually really an interesting case. So basically Newman says, almost fully acknowledges, right, that this is like a special carve-out for patent cases, but says that stare decisis basically mandates that they don't deviate from this unless there's clear evidence that there are issues with this, or there's a directive from Congress saying that they should not deal with, or that they should not continue to follow the court's current jurisprudence. Absent that, the Federal Circuit, the majority here, just basically says that they are going to continue with de novo review of claim construction. They also cite, as you typically see, with concerns of appellate review that's not deferential, they cite national uniformity, consistency, and finality. And then Judge Lurie actually, on his concurrence, basically says that even under the current standards, because the Federal Circuit does not have access to the factual record usually in these cases, that they're going to defer to the district court anyways on factual issues, and so that the standard as it is manageable, and he doesn't really want to get into this thing where we kill that standard and go to the clear error standard and basically have all of this inconsistency among a bunch of different district courts. So that's really, it's actually kind of surprising. Stare decisis is really one of the main reasons that the majority wants to keep de novo review, and then they kind of shoot holes in all of the different other justifications for going to the 52A standard. And so O'Malley and the dissent really kind of takes them to task. First of all, just saying that there's really no issue here because there are factual parts of a claim construction. that it falls within 52A6, which says that findings of fact are reviewed for whether or not they're clearly erroneous. Sorry, I may have said clear error, but whether or not they're clearly erroneous or not. And just basically construing claims requires the interpretation or the finding of fact, and so 52A should apply. They just basically say that stare decisis is not sufficient to uphold this standard, and they cite from Payne versus Tennessee, which is, I think, an oft-cited quote when people are kind of trying to diverge from stare decisis, and it's stare decisis is not an inexorable command. Rather, it is a principle of policy and not a mechanical formula of adherence to the latest decision. And basically saying that where the weight of the issue requires you to depart from your precedents, you should do it. And I think that based on basically several factors that they cite here, they think that the court should no longer follow the stare decisis in this issue. Several things that are I think pretty persuasive. One is that Markman acknowledges that there's a factual component of claim construction. So there's not even really much of a dispute whether or not there's a factual element to claim construction, even though we of course we know it's an issue of law for the court. In terms of appellate review, Markman says that it's kind of a claim construction is I think they use the word mongrel, meaning that there are elements of law and fact that are mixed in there. Sometimes claim construction might just come down to the credibility of the experts, is another thing they say. There are evidentiary underpinnings of claim construction. And also, Markman never mentioned this de novo review. There was never this explicit carve out by the Supreme Court, although they've never overturned the practice. They've never granted cert before. They never said that even though it's a strict issue, or because it's a strict issue of law for the judge, then it should be given de novo review. Instead, you see these mentions of there being a factual element to it. Also the Fuzita's standard is that is a factual standard as well. What would one of skill in the art do is kind of a factual question. Among the other considerations mentioned are that the Federal Circuit has an anemic record that's limited to the intrinsic evidence, meaning they can't really delve into the factual record like the district court judge can. And then finally, the dissent basically just says this undermines the district court's decisions. It basically lengthens litigation because you basically know that there's going to be another step, and so it's almost like an advisory opinion by the district court. So they would prefer to go to the clearly erroneous standard of review. There are some other interesting parts of this, but I don't want to get into it because I know we're just kind of doing 5 minutes. I guess I just, does anyone, so that's really the issue, and it really is lighting ballast. I think that's going to be kind of debated back and forth. It seems that practitioners and academics seem to favor the 52A standard, but I guess we'll see kind of how the court deals with it. One thing of note here, and this is pointed out by the law firm of, a practitioner from the law firm of Kelly, Dry and Warren, is that in past instances, the Supreme Court has not really favored carve-outs when it comes to the standard of review for the Federal Circuit. Specifically in Dickinson versus Zerko, the Federal Circuit held a standard of review of the Patent Office's factual findings, but the Supreme Court actually instituted the APA's standards, or standards that were kind of more standard across the entire federal landscape. So that might be kind of a good indication of where we're headed when it gets to the Supreme Court. I was just wondering, does anyone have any questions or anything that I can kind of address? I know we're kind of coming from this live link from far away, but I'd be happy to, if we can get the sync up. Yeah, sure, Joel. Sure. No, that's a really good question. Also, I like the sweater, the gray sweater, blue shirt combo. I think it's working for you, buddy. I think that, I don't think that this will completely mean that the Federal Circuit can't overturn a claim construction ruling or anything like that. Certainly, there will be kind of some fuzziness that the Supreme Court will have to figure out if they decide to overturn this practice. There will be some fuzziness they'll have to decide when it comes to what constitutes a fact versus what constitutes law. I think an interesting, if you take, for example, in the AGA 2 case where our claim construction for tomorrow was, our hearing was just canceled, but in that case, there weren't really any factual issues, that needed to be determined. The parties both agreed that how the device is. There's not really any fudging with that. What it really came down to was the legal, meaning of certain words in the patent. And I think in that case, whether or not interlacing requires, an over and under of the wires, I think that's probably an issue that the Federal Circuit could say that's just a matter of law of understanding language. That's not delving into the facts of the case. And so that would be the type of thing, that I think that would still remain, for review and everything under, a legal standard of review. But it'll be interesting to see how that kind of gets sorted out at the next level. I think another interesting, fact of this is with IPRs now, they might become a lot more attractive if you're if you're the defendant, because if you have maybe a district court judge who isn't really sophisticated technologically, then then maybe you really want to get this in front of the PTO, who has the expertise, rather than maybe have a judge who's really going to be hard to overturn at the Federal Circuit. So, yeah, I think that's one thing where you might want to keep an eye out. But yeah, if anyone else, I don't want to keep anyone too long, and I've got a beach volleyball game to get back to. We're kind of taking a time out. So if anyone has any questions, cool. Well, you guys enjoy it. I know this week's going to be kind of cold, but just power through, and I'll see you probably around June or July once it gets above 80 degrees. All right. Have a good day, guys.